Hello, everybody. Welcome to week 2 of Constitutional Law 2. This is Law 5124 here at California Southern University School of Law. This week we're going to be talking about substantive due process. It's a conversation that we will continue into week 3. You may recall the Bill of Rights was passed in 1791 and contained, among others, two important provisions for substantive due process. The Fifth Amendment states that no person shall be deprived of life, liberty, or property without due process of law, and the Ninth Amendment states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This is sort of the crux of the issue of why there was a Bill of Rights to begin with. The original Constitution was formed out of a compromise. There were many proponents that wanted a list of enumerated rights in the Constitution when it was originally passed, and others who didn't. People who thought that if you put in certain rights in the Constitution, that someone down the road would construe that to mean that those are the only rights that the people have, and they have no other rights other than what was specifically enumerated in the Constitution. And of course, the other argument was that that's nonsense, and we can put certain enumerated rights in the Constitution without it being construed that the people have no other rights. So the Constitution was passed, was ratified, and then the Bill of Rights was enacted in a couple of years to specifically make that clear. So as we discussed previously, the Bill of Rights applies to the federal government. There was a very strong demarcation between the federal and the state governments and the zones of authority that each had. The federal government was a limited institution. It had certain enumerated powers, and all the other powers were reserved to the states. This balance between state rights and federal rights and power came to a head, obviously, in the Civil War. And after the Civil War, several Reconstruction amendments were passed, including protection of the right to vote for all peoples, the abolition of slavery, and the 14th Amendment, which was ratified in 1868, which, among its other provisions, states, nor shall any state deprive any person of life, liberty, or property without due process of law. So we see an almost a mirror replica of what the Fifth Amendment requires. So the first issue we're going to talk about today is the incorporation of the Bill of Rights to the state governments. Typically, when we look at this issue now, we see the 14th Amendment's due process clause as incorporating all the rights contained in the Bill of Rights to the states. So if the federal government is prohibited from doing something in the Bill of Rights, through the 14th Amendment, the state governments are also prohibited from doing that action. Originally, though, after the 14th Amendment was ratified, that was not the case. It was seen as different spheres of power. The Fifth Amendment applied to the federal government. The 14th Amendment was an independent provision imposing a due process requirement on the states, but the two didn't have any crossover. They didn't have anything to do with each other. So we can see in the Palko versus Connecticut case in 1937 that the court was maintaining that line of authority, that not all of the Bill of Rights provisions were automatically applicable to the states. In this case, a defendant was tried for murder, found guilty of second-degree murder, sentenced to life in prison. The state appealed, and the case was remanded for a new trial, and then during the new trial, Mr. Palko was convicted of first-degree murder and sentenced to death. He stated that the retrial was a violation of the Fifth Amendment's double jeopardy clause because that was incorporated to prevent state action via the 14th Amendment. So if the federal government cannot violate the Double Jeopardy Clause because of the Fifth Amendment. States cannot violate the Double Jeopardy Clause because of the 14th Amendment. The court didn't see it that way. The court held that the 14th Amendment does not incorporate all of the rights enumerated in the Bill of Rights to the states. The court essentially held that the Fifth Amendment is much more broad than the 14th Amendment, and that the 14th Amendment does include a protection for due process, but doesn't contain that other language from the Fifth Amendment, including the Double Jeopardy Clause. Therefore, the court held that affirmed the ruling of the lower court because there was no double jeopardy violation. And I know that kind of will probably strike you as a little bit shocking that a defendant can be retried and found guilty of a harsher crime and given a stronger sentence. And this eventually was overturned much later on, after about 30 years. And the Double Jeopardy Clause does apply to the states now, but this sort of gives you that mentality of what the court was thinking at the time back in the 1930s, that just because the 14th Amendment says due process doesn't mean it includes everything from the Bill of Rights or even everything from the Fifth Amendment. Again, we're looking at Adamson versus California, 1947. The defendant was in a criminal trial. He claims that his Fifth Amendment right against self-incrimination was violated. The issue here, much like the issue in Palko, was, does the 14th Amendment incorporate the Fifth Amendment's protection against self-incrimination to the states? And similarly as to Palko, the court held that no, the 14th Amendment does not incorporate all of the Bill of Rights protections to the states. There is no right against self-incrimination in the states. The 14th Amendment only contains the Due Process Clause. It doesn't include all the other language from the Fifth Amendment. Justice Frankfurter, in his concurring opinion, essentially argued that if you tie the entire Bill of Rights to the 14th Amendment, it would deprive the states of the opportunity for reforming their own legal processes. That basically the states shouldn't be hamstrung by the 14th Amendment to always follow what the federal system holds. Justice Black did not see it that way. In his dissenting opinion, he states that the original purpose of the 14th Amendment was to extend the entire Bill of Rights to the states. So the conclusion in the Adamson case, there was no Fifth Amendment violation. We do see a change over time in this jurisprudence. We start to see in the Constitution a right to privacy. This is a very important issue. It's a very nuanced issue. There is no explicit right to privacy in the Constitution. If you read the Constitution and read the Bill of Rights and the other amendments, you're not going to see something that says that you are guaranteed a right to privacy. However, when the court was looking at these issues, it began to read into the Bill of Rights what looked like a right of privacy in certain penumbra or in certain zones. So if you look at parts of the First Amendment and Third and Fourth and Ninth Amendments, you'll see that what they held is the Constitution really implies that we do have certain rights of privacy within certain zones of our lives. So, for example, Skinner versus Oklahoma, 1942, Oklahoma had a mandatory sterilization program for repeat felons. The court held that the law violates the Equal Protection Clause because there are certain crimes that are exempt, such as embezzlement, and others are not exempt, such as theft, even though they're essentially the same wrong. In that example, they're both stealing money, but one would count towards a felon's record for mandatory sterilization, and the other one would not. Additionally, the court held that the law violates the Due Process Clause because marriage and procreation are fundamental rights. And it's this idea in the right to privacy of these fundamental rights. And you'll see that the whole issue of the right to privacy really began with the idea of marriage privacy. Privacy is one's behavior in one's own marriage. So in this situation, they're saying, look, these convicts, marriage and procreation are a fundamental right, and the state cannot take that away from them, especially in a situation like this, where Justice Stone's concurring opinion states that the due process clause is violated because there's no hearing on whether criminality can be passed on to future generations. So if you look at a law like this as preventing felons from procreating, because the idea is that they will pass on their criminality to their children. There's been no evidence of that. There was no hearing on whether that actually occurs. The law just said that, and therefore the rights that these convicts had to be married and procreate has been violated by the state of Oklahoma. So the biggest case for the right to privacy and right to marriage privacy, and this is part of the Warren Court. Justice Warren was the Chief Justice, and we see a lot of these cases coming down in the 1960s where there was a lot of individual fundamental rights that were being considered by the court. We're not going to talk about it this week, but in addition to Griswold, there was the Miranda case, the Miranda rights to someone. There was the right to counsel cases. So in Griswold versus Connecticut, we have a situation where Connecticut made it illegal to sell birth control or counsel someone in the use of birth control. Griswold was the executive director of Planned Parenthood of Connecticut, and she was arrested for providing counseling to married couples regarding birth control. So the issue here is, does the Constitution guarantee the privacy rights of married couples to receive counseling as to birth control? The rule that the court held in this case, and this is where we get the idea of certain penumbra or zones of privacy that exist, the court looked at the First, Third, Fourth, and Ninth Amendments and held that when you take these all together and you sort of read into what they're saying, that there is a zone of privacy here that protects the marriage relationship. The court, in a 7-2 decision, established this right of privacy and essentially held in this case that there's a right to privacy in marital relations. The Connecticut law infringes on the rights of married people to receive contraceptive counseling, and therefore the court struck down the Connecticut law as unconstitutional for violating this right of privacy. And so what we'll see is in 8 years, then this Griswold case becomes very important to the next group of cases we're going to talk about, and those are the abortion cases. So we look at Griswold, we look at the court saying that there is a fundamental right to privacy in the marriage relationship, and then we come up with the landmark case of Roe versus Wade. And whatever your personal feelings are on the issue of abortion, I encourage you to look at these cases for what they are, and constitutionally what law, what rules were being imposed by the court, and sort of how that changed over time, versus looking at this as some sort of moral or immoral group of cases. So let's talk about Roe to start with. Roe was an unmarried pregnant woman who wanted an abortion. Texas criminalized abortion, accepting cases to save the life of the mother. And there were a lot of issues here. We'll look at, you may remember from civil procedure, that there must be standing to bring a case to court. One of the issues here was standing, because obviously it takes a long time for a case to go through the trial process and up through appeals and up to the Supreme Court. It takes a lot longer than the 9 months of pregnancy. So Roe actually did not have an abortion. She had her child, but the court held that she still had standing to bring the case, because obviously nobody can ever get a case to the Supreme Court that quickly, and this issue would never get resolved if we're constantly getting thrown out on standing grounds. But for our purposes here, for substantive due process, we're looking at the issue of whether the abortion laws in Texas that do not take into account the stage of pregnancy or any other concerns violate the Constitution, and whether the Due Process Clause of the 14th Amendment protects a pregnant woman's right to have an abortion. The court looked at these issues and held on both counts, yes, the Texas law is unconstitutional, and the 14th Amendment protects a woman's right to have an abortion. And this case kind of resolved a lot of state cases. There were some states that criminalized abortion. There were other states that allowed abortion, and some mix of the two. Much like what we see now with the criminalization of marijuana or the legalization of gay marriage. So that's what we see. We see some states that were outlawing abortion, some that allowed it. In this case, sort of laid them all out. So the court held that the laws in Texas violate the 14th Amendment. It adopted the trimester approach. During the first trimester of pregnancy, the woman has a near unfettered right to an abortion. She has a privacy interest in her own body and protecting her own health and making decisions for herself. The state cannot intervene in the woman's right to privacy to her own body in the first trimester. Now, in the second trimester, the state does have some interest related to the health of the mother and the potential health of the fetus and the potential for life. So states can regulate in the second trimester related to the health of the mother. And then we see in the third trimester, the states have an interest in the potentiality of human life, and they can regulate or even prohibit abortions, except when it's necessary for the life or the health of the woman. So this is the rule. This is the trimester approach to the abortion cases. The court held that there's a right to privacy here. That right to privacy is counterbalanced by the state's compelling interest in protecting the life of women and in protecting the potentiality of life in the fetuses. This ruling stood for a while. It is still good law, although the rule of what abortion restrictions are unconstitutional has changed over the years. In 1989, the court decided the case of Webster versus reproductive health systems. In this case, Missouri enacted a lot of restrictions on a woman's right to an abortion, including prohibitions against counseling for abortions, mandatory viability tests for anybody that was over 20 weeks pregnant, and there was a complete ban on the use of public facilities and public employees performing abortions. The opinion here was written by Chief Justice Rehnquist, who was he was appointed as Chief Justice by Reagan. He was a conservative justice, and this is a fairly conservative opinion. The court essentially held that the government does not have to get into the business of abortion. You can't force governments to pay for abortions. The court also held that the viability tests were proper because the state has an interest in the potential life of the fetus or the baby, even possibly before the point of viability. This sort of lays the groundwork. It knocks Roe off of that strict trimester approach and lays the groundwork for what the court should take into account, the states should take into account, not only the health of the mother, but the potential viability of the fetus, whether that be before the second trimester or after the second trimester. And so what we see is just a few years later then in Planned Parenthood versus Casey, Pennsylvania law had a number of abortion restrictions, including a 24-hour waiting period. There's a parental consent requirement for minors with a judicial bypass, and what that is they either have to have the consent of their parents, or if they feel like they cannot get the consent of their parents, that they can go before a judge, and a judge can hear the case and determine whether or not they're allowed to have an abortion. And the other restriction was that there was a requirement for notification of the husband in cases where the woman carrying the baby was married. The court upheld most of the restrictions, but created a new test. And the test is whether the state abortion regulation has the purpose or effect of imposing an undue burden. And undue burden is one of those magic phrases that you'll hear from time to time, which is defined as a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. So the new rule is, does the abortion restriction create an undue burden on the woman to prevent her from getting an abortion? Does it create a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability? Now remember, once the fetus is viable, that the rule does change. There's a lot of consideration as to the health of the mother, viability of the fetus, the state's interest in potential life, the mother's right to privacy, the mother's interest in her own health. But before viability, if the regulation creates an undue burden to act to prevent a woman from having an abortion prior to the time that the fetus is viable, then the regulation will get struck down. And the court held that out of all the Pennsylvania restrictions, the restriction that the husband must be notified of the abortion prior to a married woman having an abortion fails the test, because this is a requirement that was placed on the woman to inform her husband even if she was still in the first trimester. And then finally, the last case we're going to talk about is Stenberg versus Carhart in 2000. And you'll see a lot of these cases were coming up at the time in the 90s and in the 2000s, the so-called partial birth abortion bans. So Nebraska, among a number of other states, enacted a ban against partial birth abortions, which is a procedure where the fetus is induced to be born and either is partially born, is partially moved out of the uterus and into the birth canal for the purpose of the doctor performing a procedure that ends the life of the fetus. A lot of people have very strong opinions on this issue, so it's really, you can sort of understand why this got to be a very hot button issue at the time. So the issue the court saw was, does a complete ban on partial birth abortion, and which did not include an exception to save the life of the mother, whether this ban violates the 14th Amendment Due Process Clause by placing an undue burden on the right of a woman to have an abortion pursuant to the Casey decision that we read earlier. The court held that this ban is unconstitutional because there are cases out there where the partial birth abortion is necessary for the life of the mother and is the safest method of abortion, and the law does not take that into account. The law just creates a blanket ban on partial birth abortions. This was a very fractured opinion, 5-4 decision. Justice Kennedy even wrote in a concurring opinion that he doesn't believe the court is in the position of being able to evaluate different methods of abortion and what's proper and what's not. So what you see is, even something like partial birth abortion, which a lot of people were against, it does not have an exception to save the life of the mother. It didn't take into account that sometimes that's the safest method for abortion. The court struck that down. That's the discussion, the end of the discussion we're going to have this week on substantive due process. Read these cases carefully. I know you're required to brief one or more of these cases this week for your homework. If you have any questions, please contact me, and we'll see you back next week for the remainder